Welcome back to another deep dive. Today we are staring into a legal abyss that, at first glance, looks like a complete paradox.
It really does.
We're tackling a concept that baffles law students, it absolutely frustrates prosecutors, and, it probably drives the average person a little crazy.
It's one of those topics where your gut instinct and the actual letter of the law are like almost in a fistfight. We're talking about the intent paradox in attempted murder.
It is a paradox.
Yeah.
Let's start with the riddle we're trying to solve today. Here it is. How is it possible that a criminal can have a mental state that is undeniably bad enough to convict them of murder if the victim dies?
Right.
But that exact same mental state is legally insufficient to convict them of attempted murder if the victim lives.
It sounds completely counterintuitive, doesn't it? You would think attempted murder is just murder minus the dead body.
Exactly. If I shoot someone and they die, I'm a murderer. If I shoot someone and they live, I should be an attempted murderer. The logic feels so linear. But that's not how it works.
No, not in Illinois, and not under the logic of the common law. The law draws a very, very strict line between bad outcomes and bad intentions. And to understand why, we're going to do a deep forensic analysis of a landmark Illinois Supreme Court case, People v. Harris.
Okay, People v. Harris.
This case is basically the master key to unlocking why almost isn't enough.
And to get there, we have to look at the clash between two statutes. Section 84A, which is attempt, and Section 91A, which defines murder.
And that's where the friction is. We're going to resolve that friction using the doctrine of specific intent. And by the end of this, you'll understand why the law might let a very dangerous person walk on an attempted murder charge.
All right, let's unpack this. Before we get to the actual shooting in the Harris case, which is a wild story, we need to lay the foundation. Can you start us off with the fundamental definition of attempt?
Sure. So the general rule for attempt comes from Section 8.4a. It's a two-part test, really. First, you have to have the intent to commit a specific offense. And second, you have to perform an act that is a substantial step toward that offense.
Simple math, then. Intent plus a substantial step equals attempt.
Right. But here's the catch. You have to ask, what is the specific offense we're talking about?
Well, today it's attempted murder. So the specific offense is murder.
Exactly. So logically, we have to look at the definition of murder to see what we're attempting to do. And this is Section 91A. And this right here is where the complexity just explodes.
I see.
Because the statute for murder is actually pretty broad. It creates 3 different mental states, what we call mens rea, that can make you a killer.
3 different buckets.
3 buckets, yeah. Bucket 1, you had the intent to kill or the intent to do great bodily harm.
Okay, so that covers deliberate killers and also people who just want to hurt someone really, really badly.
Bucket 2, you knew that your acts created a strong probability of death or great bodily harm.
Ah, so that's the guy who fires a gun into a crowd but says he wasn't aiming at anyone.
Exactly that guy. He knows there's a strong probability. And then bucket 3 is felony murder, killing someone while you're committing a forcible felony, like a robbery that goes wrong.
Okay, so here's where I'm getting stuck. You just said that for murder, it's enough if I have the intent to do great bodily harm or if I know there's a strong probability. So why can't those apply to attempted murder? That's the friction point, right?
That is the friction point, and the answer is the specific intent limitation. You have to look at the word attempt. To attempt something, you must intend to achieve the result defined by the crime.
And the result of murder is death.
The result of murder is death. The result of great bodily harm is, well, it's harm, it's not death. So you cannot attempt a result you didn't specifically intend. You can't, for example, attempt to accidentally kill someone. You can't attempt to create a probability.
Wow. That's a head scratcher. So even if I act with total recklessness or I'm trying to break someone's legs, I can't be charged with attempting to kill them?
That's right. If the charge is attempted murder, you can only attempt to kill. Nothing less is good enough.
Okay, let's test this. There's a case, People v. Visor, that deals with that third bucket, felony murder. How does that fit in here?
Visor is the perfect illustration. In felony murder, let's say you're robbing a bank and you accidentally hit a security guard with your getaway car. You didn't intend to kill him, but he died during your felony. That's murder.
Right.
But could you have attempted felony murder? The court in Visor said absolutely not, because felony murder, by definition, doesn't require an intent to kill. It's an accidental killing.
You can't try to have an accident.
You cannot try to have an accident. It's a logical impossibility. If you intended to kill the guard, it wouldn't be felony murder. It would just be intentional murder. Visor shows us that without that specific intent to kill, the whole concept of attempt just falls apart.
Okay, this is starting to click, but it's still pretty abstract. We need to see this in action. Can you give us a scenario to really crystallize the difference between intent to kill, intent to harm, and recklessness?
Of course. Let's use the classic A, B, and C hypothetical. It's what every law student learns to get this distinction down.
Okay, lay it on us.
Imagine 3 people, A, B, and C. Each one shoots a victim.
Okay, 3 shooters. What's in their hands?
So person A shoots with the specific intent to kill, aims for the heart, wants the victim dead.
Cold-blooded. Got it.
Person B shoots with the intent to do serious bodily injury. Maybe they're a loan shark, they aim for the kneecaps, they want to send a message, but they specifically do not want the victim to die. Dead men can't pay their debts.
Right, so B wants pain, not death.
Exactly. Now, person C shoots with reckless disregard for human life. C is drunk, fires a gun wildly into a crowded room to scare people. They don't want anyone to die, but they really don't care if it happens.
Got it. A wants death, B wants injury, C doesn't care. Now, outcome 1. All 3 victims die.
If all 3 victims die, A, B, and C are all guilty of murder, the law accepts all 3 of those mental states as enough for a murder conviction.
Okay, that feels right. All did something terrible, people died, they all go away for murder. But now for scenario 2. The victims survive.
This is where the trapdoor opens. If the victims survive, only A is guilty of attempted murder.
Only A. Wait, even though B deliberately shot someone in the kneecap, even though C was firing into a crowd like a maniac.
That is correct.
No.
Only A. The reason is that B and C lacked the specific intent to bring about the death of the victim. B intended harm, C was reckless. You can get them for aggravated battery, for reckless conduct, sure, but you cannot convict them of attempting to murder someone they did not consciously intend to kill.
That distinction is just razor sharp. Okay, now we have the theory. Let's dig into the main case that set this all in stone. Let's analyze People v. Harris. First, what are the legally dispositive facts?
So it's a domestic dispute that escalates fast. The defendant, Harris, and the victim, Joyce Baker, are arguing in a car about infidelity. He's accusing her of seeing someone else. And it gets really heated. Harris picks up a revolver from the floor, points it at her, and starts making threats. Baker, terrified, opens the car door and just runs for it. In her panic, she runs right into a barbed wire fence and hurts her leg.
Oh, wow. So she's injured, scared, running away.
Right. She manages to get back to the car, gets in the driver's seat, and starts to drive off to escape him. As she's pulling away, Harris stands behind the car, holds the gun with 2 hands, which is key, it suggests he's aiming, and he fires a shot.
He shoots at the car as she's fleeing.
Yes. The bullet shatters the rear window. The police later find a bullet fragment on the rear seat. Baker herself wasn't hit, but he clearly fired at the car.
And what was the core legal issue on appeal?
The whole issue was whether the jury instructions were wrong. Specifically, were they erroneous because they included the murder definition involving intent to do great bodily harm instead of just intent to kill?
They gave the jury the wrong mental state to look for.
They gave them too many options.
Okay. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The rule is that synthesis of the attempt and murder statutes. For attempted murder, the state must prove 2 elements. Element 1, the defendant performed a substantial step toward the commission of a killing. And element 2, the defendant possessed the specific intent to kill. Not just to harm, not to be reckless, the specific intent to cause death.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the substantial step?
That part was easy. The court basically said, yes, shooting a gun at a car someone is driving is obviously a substantial step. That element wasn't really in dispute. The whole fight was about the mental state.
Understood. Now, what about the second element, specific intent to kill?
So here's a mini iris. The sub-issue was, did the jury instructions correctly define that intent? The sub-rule is that attempt requires the specific intent to commit the offense, and the specific offense here is killing. So you need intent to kill.
Right.
The trial court, in its application, instructed the jury they could convict if Harris intended great bodily harm. That instruction follows the murder statute, but it fails the attempt statute. It allows a conviction without finding an actual intent to kill. So the conclusion was the instruction was legally defective.
And after analyzing all the elements, what was the court's final conclusion?
The conviction was reversed and remanded for a new trial. The court said the error was not harmless because the jury might have believed Harris only wanted to hurt Baker or maybe just shoot out the tires. And if that's what they believed, he's not guilty of attempted murder.
Wow. And the Harris court didn't come up with this out of nowhere, right? It relied on an earlier case, People v. Trinkle.
That's right. Trinkle is the one that really tackled that strong probability language.
Okay, let's analyze People v. Trinkle. First, what are the legally dispositive facts?
In Trinkle, the defendant was really drunk at a tavern. The bartender cut him off. He got angry, threatened to shoot or blow up the bar. He left, bought a gun, came back, and fired one shot at the front door of the tavern.
Just at the building.
At the door, yes. But the bullet went through the door and hit a patron who was standing right behind it. And crucially, the defendant had no idea anyone was standing there.
And what was the core legal issue?
The issue was whether the indictment and the jury instructions were valid when they charged attempted murder, based on the defendant knowing his acts created a strong probability of death or great bodily harm.
So they were using bucket 2 from the murder statute. What rule of law did the court apply?
The exact same rule as in Harris. Attempted murder requires specific intent to kill. Knowledge of a strong probability is not enough.
So for the court's elemental analysis, how did they apply that element of intent?
Another mini IRACL, the sub-issue, is knowledge of strong probability, the same as intent to kill. In its application, the court noted the instruction came directly from the murder statute, section 922. And while that works for a murder conviction if the victim dies, it describes a reckless state of mind, not a specific intent to kill.
So it's not good enough for an attempt.
It is not sufficient. That was the court's conclusion on that element.
And what was the court's final conclusion in Trinkle?
The indictment and the instructions were defective. The conviction was reversed.
This standard is just so strict. But there was one case that went the other way for a while, right?
Yeah.
A case the Harris court had to deal with directly.
Yes. They had to clean up a prior ruling, People v. Muir.
Finally, let's analyze People v. Muir. This one seems the most clear-cut. First, what are the legally dispositive facts?
In Muir, the defendant pointed a pistol at a police officer who was approaching him. He pulled the trigger. The gun jammed.
Whoa.
He then ran away, turned, pointed it at the officer again, and pulled the trigger a second time. It jammed again.
Okay, that sounds like a pretty specific intent to kill a cop. And
Right.
what was the core legal issue?
The issue was the indictment. It charged attempted murder by alleging the defendant knew his acts created a strong probability of death or great bodily harm.
They used the wrong language again. So what rule of law did the Muir court apply at the time?
At the time, the Muir court actually allowed it. They sort of fudged it. They said, because the indictment also alleged intent to commit murder, the strong probability language was okay. It was surplus.
So let's move to the elemental analysis in the context of Harris. How does the Harris court treat that Muir ruling regarding intent?
Okay, final mini IRA. The sub-issue for the Harris court was Muir correct to allow those instructions?
Yeah.
In its application, the Harris court expressly overruled that part of Muir. They said even if the facts are terrible, even if it seems obvious the guy wanted to kill the cop, the legal instruction to the jury cannot lower the bar. The law demands precision. And their conclusion was that Muir was simply error on that specific point.
So we have the doctrine, the hypotheticals, the cases. For any listening, how do we synthesize this into a practical framework? A checklist for spotting this issue?
Absolutely. Think of it as a diagnostic checklist for an exam or just understanding a news story.
Okay, what's step 1?
Step 1, classification. First question you ask is the charge attempt? If yes, a light bulb has to go off in your head. You immediately shift to the special rules for attempt.
Okay, we're in attempt world. Step 2.
Step 2, isolate the target offense. What crime were they trying to commit? Here, it was murder.
Simple enough. Step 3.
Step 3, the intent filter. This is the crucial one you have to ask. Does the evidence show a specific intent to bring about the end result of that crime? For murder, the result is death.
And this is where the red flags come.
And this is your diagnostic flag. If you hear or read the phrases great bodily harm, strong probability, reckless, or felony murder used as the mental state for an attempt charge, reject it. Full stop. It's legally insufficient.
It's like a litmus test. If it doesn't say intent to kill, it fails. What's the last step?
Step 4, substantial step. This is usually secondary, but did the person actually do something? Did they pull the trigger, buy the poison? Did their action go beyond just thinking about it?
So a conviction for attempted murder requires clearing all those hurdles, especially that very high bar for specific intent.
That's right, and it really comes down to a core legal philosophy. The law protects a defendant from being punished for an intended result death that they never actually had the specific mindset to create.
Even if their actions were incredibly dangerous.
Even then, we punish them for the mind they had, not just the harm they almost caused.
It's a high bar, but it ensures that we don't equate being reckless with trying to be a killer.
Exactly.
Well, that wraps up our deep dive into the intent paradox. It's one of those things that, once you see it, you really can't unsee it.
You notice it everywhere now.
Just remember, in the eyes of the law, aiming for the kneecaps is a completely different crime than aiming for the head. Thanks for listening, and we'll see you on the next deep dive.